Hello everyone, it's Mark and welcome back. In this video I want to talk to you about the concept of being, quote, re-Baker Acted. Re-Baker Acted. So I've had calls from a number of families who tell me their loved ones were held in a facility for up to 72 hours, they weren't released, and then the facility, quote, re-Baker Acted them. Okay, I'm here to tell you that that is a term that has been made up by a Baker Act facility. It simply doesn't exist. It's not in the Baker Act statute, which is Chapter 394, and it's just an excuse to keep somebody even longer than they should be there. So if your loved one has been held in a facility involuntarily, that means the facility has up to, not 4, but up to 72 hours to do one of two things. Either assess and stabilize you and release you, or they are required to file what's known as a petition for involuntary placement, which basically means they are going to court and asking a judge for permission to keep you beyond the 72-hour period, potentially for a period of up to 6 months. Okay, but in order for that to happen, once they file, there is going to be a hearing. You're entitled to due process. You're entitled to see a judge. You're entitled to have the state prove their case against you. But this whole idea that you've been, quote, re-Baker Acted, that is just a BS term made up by a Baker Act facility to deny you your right to be free, to have liberty, to have due process, to have the right to counsel. And it simply doesn't exist. So if your loved one has, quote, been re-Baker Acted, we need to talk, and we should talk quickly, because it's a small window of time to get your loved one out. Anyway, with that said, thanks for tuning in. See you in the next video. Bye-bye.